Good evening, everyone. Welcome to the week 3 tutorial. Sorry, Glenn, go ahead. You've got your microphone off now. We might hold on to your question. We might circle back to it. So welcome to week 3, everyone. This week, we're going to be talking about merits review, which is a really important and really useful step in the administrative law umbrella. We'll talk about some of the reasons for that in a minute. As always, what I'm going to do is just quickly start off with a very brief summary of the topic, and then I'll open it up to any questions or concerns. So let's start off in thinking about merits review. We've talked in last week a little bit and in the lecture videos, and you will have noticed in the readings as well. Merits review is really an alternate to judicial review. It's a process that stays within the executive branch of government, and that brings with it a bunch of advantages and disadvantages. But one of the things that's really worth noting right at the outset is that merits review isn't always available. And so when we're encountering, for example, a hypothetical problem in the written assessment, hint, involving merits review, the first thing we need to do is ask ourselves whether merits review will be available or not. And so the sort of threshold criteria there is first to establish whether merits review is authorised under the primary act. So the particular act that authorises an administrative decision. So for example, Veterans Entitlements Act or Social Security Act, a whole range of different acts, they will say, they've got the part of the legislation that enables a decision maker to make a decision. And then elsewhere in that act, there will be a provision empowering some other body, a merits review body, to review the decision. So a good example is, a section that says a decision made under this act is reviewable by the AAT, or a person affected by a decision made under this act can ask the AAT for a review of this decision, things like that. So it's specifically empowering some other merits review body to engage in a review of the decision. We contrast that with judicial review, which we'll talk about later in this unit, which is almost always available and you don't need express permission from the primary act to obtain judicial review, whereas you do for merits review. So when we're looking at legislation, we're keeping an eye out for provisions that say, what the review process is. And if there is a review process, it might indicate to us that its merits review is available. One thing that is worth noting is that it's unlikely that the legislation itself will just say merits review is available. You tend not to see that language used, but instead it will refer to a particular body, usually a tribunal, sometimes an ombudsman, that's empowered to undertake merits review. So for example, and the main example that we'll be going through in this unit is the Administrative Appeals Tribunal. So primary acts say you can ask the AAT to review a decision made under this act, something like that. The other thing that's really important when we're thinking about whether merits review will be available or not is whether the applicant has standing, whether they're affected by the particular decision. And we don't need to dwell on that for too much at this stage, but it's worth noting just because under Section 27 of the Administrative Appeals Tribunal Act, that does provide that you need to have standing in order to access merits review. The next sort of question is, okay, well, if merits review is available, sorry, I've just noticed Stephen's asked a question in the chat. Does this mean that the AAT has jurisdiction? Yes, so the AAT would have jurisdiction to hear a particular review. They're empowered to. Jurisdiction's maybe a tricky word because it, we tend to think of that more in the legal setting, but it's the same idea that the AAT is empowered to engage in the review. So the second question then is, what can be reviewed? And what's really important to keep in mind with merits review is that we can review questions of law, questions of fact, and matters of policy, which is a much bigger much broader scope than judicial review, which can only review questions of law. So it's worth quickly recapping on the difference between a question of law and a question of fact. Question of law is a legal issue, and we're really thinking about, was a particular procedure followed correctly? Was the required form filled out in the proper manner? So there's a factual element in the sense that it's referring to, a thing or an action or something like that. But really what we're focused on is the form, the process, something that's required by the law. Question of fact is much more heavily emphasized on the factual matrix itself. And so we talked in the lectures about the example of whether a dog is dangerous or not. That's really emphasizing the facts in terms of, is the dog big? Is it, a particular breed? Has it bitten someone before? These sorts of things. They're all factual. They're grounded in the factual matrix that, for example, you would get given in a hypothetical. And they're not really tied to the legislation so much. Whereas a question of law will really focus on, were the right steps followed? Did the proper person make the decision? Did they go about the process in the right way? And things like that. From there, we can think about, okay, well, the AAT and other merits review bodies can review facts. That's really great. Which facts can they review? Well, it depends on the primary legislation. Sometimes you're restricted to reviewing the facts that were before the decision maker at the time the decision was made. Otherwise, we've got what's called the de novo hearing, where new evidence and new facts can be brought to light, and the review body can make use of that fresh evidence as well, which is really important. Last question then is, well, how should the review work? What's the process? Again, this will depend on what the primary act establishes. Some acts, for example, will only allow the review body to set a decision aside and remit it back to the original decision maker to remake the decision. Other merits review bodies are empowered to actually stand in the decision maker's shoes and make the decision anew if they think that there was a problem and they need to substitute their own decision for that of the original decision maker. But the guiding principle here comes to us from Drake, and the standard is usually the correct and preferable decision. So making sure that the decision was correct, legally correct, and preferable on the facts was the preferred decision. So that's the standard. And then following on from that, the review body's particular powers will be guided by the primary legislation. So, for example, the Administrative Appeals Tribunal often will be allowed to, for one, hear matters de novo, so they can hear new evidence, and they'll be empowered to remake the decision, to substitute their own decision for that of the original decision maker, and it will be as if the original decision maker had made that decision instead. So that's a very brief, recap of merits review. Stephen's asked in the chat, how do you know if a de novo hearing applies? Again, we're guided by the primary legislation. So the same act that allows the decision maker to make the decision, that allows an appeal or a review to, for example, the AAT, will say something along the lines of, and it will usually be sort of a subsection within the provision allowing a review. It will say, this is the review body, the tribunal, whoever, is limited to evidence that was before the decision maker at the time the decision was made, or they'll be able to, or it will say, have broader terms and will say, the tribunal is not limited to facts that were before the original decision maker or something like that. So we're guided by the primary legislation as well on that one.
When you say the primary legislation, you mean, say, the Social Security Act that refers to the AAT, but not the AAT itself.
Yeah. So, and that's sort of the tricky thing about the AAT and merits review broadly is that it's contingent on all these other primary bits of legislation. So, you know, there are over 400 individual other acts, primary acts, that allow matters to be referred to the AAT and stuff like that. There's nothing actually in the AAT Act that says the AAT can review, you know, social security decisions or veterans entitlements decisions, things like that. It's all those other individual acts that say a decision under this act can be reviewed by the AAT. So it's all the primary legislation, all these other little laws that empower the executive to make decisions, feeding into the AAT or the other review bodies and things like that. So and I suppose this is important from an assessment perspective. Obviously, it's important from a practice perspective, but it's important from an assessment perspective. You'll be given a sort of a chunk, not the whole law, obviously, but a chunk of primary legislation. And you'll use that to guide your answer and then use your knowledge of the AAT Act and things like that as well to guide your answer to the hypothetical question. Glyn has asked, is the Drake meme format permissible in an answer? If you wanted to make me laugh while I mark your essays over Christmas, you could include one in, but it wouldn't get you any additional marks. Any other questions about merits review or the ways in which merits review interacts with the reasons for decision that we talked about last week and things like that?
Sorry, I've just got a very quick one. It might be a silly question, but in the event that there's a dispute about the breadth or the depth that the AAT can go into with their reviews, for example, if a de novo is available, who decides that?
Wow. And see, I don't know if I've mentioned this in any of the lecture recordings. I think I was going to, and then I think I decided not to, just to try and keep things simple. But when we want to get really, you know, into the weeds of administrative law, because the AAT and other merits review bodies are still within the executive, its decisions themselves can be reviewed as part of the judicial review process. So, and you see it happen all the time. The AAT, there's a decision made, it gets reviewed by the AAT, you know, one party loses and is not happy with that decision. So they then ask for judicial review of the AAT's decision. And one of the things that might come up, because judicial review is restricted to errors of law, you could argue that the AAT made an error of law in accepting new evidence as part of a de novo hearing when it shouldn't have been, or something like that. So the ultimate arbiter of a dispute about whether a hearing is de novo or not will be the court under a judicial review process. Does that make sense?
Yeah, perfect sense.
So yeah, it's a little bit tricky, and to keep the unit a bit more simple, I shied away from talking about when merits review morphs into judicial review. But yeah, there's a mechanism for that that does happen fairly regularly.
Jacob, I had a question.
Sure thing.
It might be silly, but it's more about case citations. So
yes.
I've been doing a bit of reading, and I've noticed that the tribunal cases use the and instead of versus. Is that because it's not a court?
Yeah, it's and it reflects this sort of the unique and interesting position that merits review bodies are in, where they don't have to be adversarial in their conduct. They can be a bit more inquisitorial. And so, yeah, where the sort of the versus in courts, in court cases, refers to the really adversarial relationship between the parties. Because tribunals don't have to be so adversarial, you do see and as rather than the V from time to time. Yeah. Excellent. These are good questions. Any other questions while we're on a bit of a roll? Cool. All righty. Well, we might move on and then we can circle back if anyone's got any other questions at the end. Question 1 for our weekly questions today is, what are the advantages to having the AAT instead of the courts review an administrative decision? Why would we want to go down the route of the AAT and merits review rather than going straight to court? So Jamie Lee said that it's less expensive and more efficient. Kat has said that they can take all evidence into account, quicker to process and not as costly. Yeah, absolutely. Caroline saying cost as well. So yeah, definitely cost emerging as an answer. And that's absolutely right. It is cheaper to go to the AAT. Still pretty expensive these days, but cheaper than the court system, which is, obviously a big deal for a lot of people. Brooks noted that it's not restricted to legal questions, more broad. Absolutely. So being able to look at questions of fact and to address questions of fact is really huge, because it completely opens up the decision-making process. And I think that ties into Jessica's statement as well, that it helps to identify mistakes right across the process rather than just mistakes of law. Gory's mentioned as well that sometimes they can be a bit more specialized in relation to the subject matter, and that's very true. So we tend to see it more in relation to some of the smaller, more specific tribunals rather than the AAT, but the AAT can do it too. The use of specialists and the role of, I guess, non-lawyer specialists actually sitting as tribunal members can be a really good thing about the process as well, because it can make the decision making, where something is really technical, it can make for better decisions and better review of decisions. Absolutely.
I just have a question, Jacob.
Yeah.
Is leave required for legal representation?
Depends on the tribunal. Usually not, but some of them that do try and be really kind of a lot less formal and have a lot fewer barriers. I'm trying to think of an example, and none are coming to mind at the moment, but some of them are designed to be a bit more informal. But as a general rule, you can have legal representation. That's no problem, but not always. Yeah. Any other thoughts? What about the outcomes that you can obtain from the AAT versus going down the courts and the judicial review process? Are they the same, or are there differences? Can be different decisions reached? Absolutely. And what's sort of the key distinction between the two in terms of the decision? So yeah, Gemma has said they can vary the decision made. Stephen's identified that they can substitute the decision. Yeah, absolutely. So a court in the judicial process can only set a decision aside, and then, there's some very limited remedies around making a declaration of a party's rights, or putting in an injunction or something like that. But a court cannot remake the decision for the decision maker, whereas merits review and the AAT can. They can say, no, this was the completely wrong decision. The decision you should have reached is this. So we're going to save everyone the time and hassle, and we're just going to make it. And that's the new decision that stands, which, in addition to the actual process itself being cheaper, saves you the cost of then, going through the application process again or something like that as well. Kat has also said that the evidence and the types of evidence is different as well. So the way in which the AAT hears evidence, in the sense that they can be inquisitorial and actually go on a bit of a fact-finding mission themselves, is another important distinction. And they've sort of got a broader remit to hear the traditional rules of evidence don't necessarily apply to the AAT. So they can hear, evidence that's hearsay, non-expert opinion, things like that. So that's an important distinction between those as well. I'm pretty happy with all of those answers. I'm just keeping an eye on the time. We might skip over question 2 and circle back to it if we have time at the end, because I do want to make sure that we get plenty of time to talk about question 3. I won't read the full thing out, but it's a good example of sort of being given a section of primary legislation to then build on with your knowledge of merits review. So very briefly, we're talking about the Security Personnel Act 2015, which is not a real act, but it's based on some Queensland law, which deals with security providers like bouncers and security guards and things like that. And basically the scenario that we've got is that you have to have a license in order to be a security guard, and whether you get a license is determined by the chief executive on the conditions that you're 18 or more, you've successfully completed a training course, and that you're determined to be an appropriate person to hold a license. And the factors that go into being appropriate or not involve, do you have a criminal record, a bit of a background check and things like that. You've got the right to appeal to the AAT if you don't like the decision, and the AAT is unaffected by the chief executive's decision and can confirm it, set it aside and make a new one, or make some other order. We've got a client, John, who wasn't unemployed, applied for a license, didn't get one, and has been told that the reason he didn't get one is because he was convicted of a criminal offence when he actually wasn't. He lied on his application, and he would not diligently carry out his duties to be employed as a security guard. So we're in the position of advising John. So what I thought we'd do is we'll sort of collect all our initial thoughts and impressions about this particular scenario, and then we'll gather all that together, and then we'll take a step back and work through how we would construct an answer, and a good quality answer to this particular problem. So what are the initial thoughts? What's going on with John here?
I think the executive made an error in getting the names incorrect. I've got a skeleton answer I can post stuff. It was done at 3 a.m. in the morning, so I don't have everything up.
Yeah. Well, we might, when we go through sort of constructing an answer, if you're happy to share that around, that might be really good. So we might circle back to that one if that's all right. What are some of the other? So the error of, I guess, looking at the wrong person's criminal history, yeah, absolutely is going to be a key factor to look at. What else?
He can go to the AAT because that section 26 says you have a right to take it there.
Yeah.
But my question would be, I just quickly looking through it, does he have a right to introduce new evidence or not? Is that covered by the scenario?
Yep. What other people think?
I think part of it, if I read it properly, said that they're not limited to what the executive or what the chief decision maker or whatever has. So which means that they probably would be able to look at other stuff.
Yep, absolutely. So in looking at section 26, subsection 4, in substituting another decision, the AAT has the same powers of the chief executive. So the same powers being those powers to make inquiries and to look at the things in, section 11, 2 and 3 about, determining whether someone has shown honesty or lack of integrity. In collecting the evidence to make those decisions, they've got the same powers as the chief executive, which means that they can go out and obtain new evidence. What what would indicate to us that it wouldn't be a de novo hearing in this instance would be if subsection 4 says, in substituting another decision, the AAT is limited to the information that was before the chief executive, or some other limitation on the way that the AAT exercises its powers to find out information and substitute the decision if it needs to. Does that make sense? Cool. I'll just catch up on the chat. So issues are in section 11, 3A and 3B. So the kinds of things that the court, that the chief executive can be looking at to decide if someone's appropriate or not. Absolutely. Michael, reference to diligence in decision is not a disqualifying point. So if I'm understanding you correctly, Michael, what you're saying is that the fact that John was always late shouldn't disqualify, it's got nothing to do with whether he's appropriate to be a security guard or not. Yeah, we can definitely work with that one. Kat says John will need to request a review and provide new evidence of identification. Yep. So coming back to this idea that, the wrong records for the criminal history were provided and we need to correct that. Yep. Gemma, is the letter that John received enough, or should we be requesting the reasons for decision? What do we think? Using our knowledge from last week, is what's been provided there as a reason enough? Or would we want more information about the decision, do we think? Definitely request reasons. Okay, good. Yes, absolutely. So what in particular is missing from the reasons that have been given? So evidence, yep, absolutely. What were the documents and the evidence used to reach the decision? And even in terms of the facts that went into the decision as well, right? The decision, we can guess at the facts that the decision maker has relied on based on the facts that we do know, but it needs to be clearly stated as well, because that goes into our review of the decision too. Cool. Okay. We're going well. Anything else that anyone wanted to raise in terms of things that would need to be looked at or are relevant to this answer? Do these things have to be supplied to the AAT automatically? When you say these things, do you mean the reasons or?
I just read somewhere that once you lodge something with the AAT, the other party has to give their reasons and their evidence as part of the proceedings rather than you seeking them yourself.
They might have to. I've always tended to just go in with asking for the reasons as a matter of course, straight up. The answer will be in section 28, I would say. I can't see anything there about it having to be supplied, but it's possible that it is in there somewhere. For the purposes of constructing an answer for the hypothetical, I would look at those as being separate things, asking for the reasons yourself rather than it just going through the review process. I'll just catch up with the chat here. So section 28(1) of the AAT Act says that that if you're appealing or if you're entitled to make an appeal to the tribunal for a review, they can apply to the tribunal for a review of decision and request that the person So the person who made the decision give the applicant a statement in writing to set out the findings in relation to fact, evidence, and the decision. So it goes, if you're entitled to the review, it goes through the tribunal process, but it's still a separate thing. The reasons are coming from the decision maker to the applicant rather than to the AAT. Okay, so this is good. We're going well. There are a couple of other things that we should probably think about before we go straight into the answer. Are there any time limits that are going to apply here? Where, in terms of, does the primary legislation say anything? And if not, what does the AAT Act tell us about timings and things like that? Yep, so 28 days, if not varied by the Primary Act. And there's nothing that we can see in the Primary Act in terms of the provisions that we've been given that says anything different. So we run with 28 days per Section 29 of the AAT Act. Excellent.
Would it be safe to assume that the 28 days does not include the day of the original decision?
It's from the day that notice of the decision was given, which is
not including that day, or?
Well, you tend, so it's a little bit tricky, but it's the day that the decision was made, within the actual department itself or wherever, is not necessarily the day that notice was given. But equally, the day notice was given is not necessarily the day that you found out about it. So generally you're finding out about these things via a letter. And so we're looking for, and in this particular scenario, we don't have one, but in general, we're looking for the date of the letter. So, the letter might be dated 23rd of November. 28 days from then, the decision might have been made at 4:30 on the 22nd, but that doesn't count. You might not get that letter until the 26th, but we're doing 28 days from the 23rd of November.
Apparently, if you live in Pennsylvania, it may take a little longer.
Is this a vote counting joke?
Yeah.
Cool. So yeah, so looking at the Acts Interpretation Act for guidance on that issue as well. Cool. So 28 days. I think
Jacob?
we've covered. Yes.
So when we're going into the answer now.
Mm-hmm. Sorry, your microphone's just turned off again there.
Yes, I picked up in the answer that because he's unemployed, there's a fee involved. He's able to get a waiver. Would they consider that?
As in?
Sorry, creative thinking. Yeah. I'll just post my answer really quickly. Yeah, because it's on the questions there. They're saying that the application would need to be like there's an application fee. So if you go to a tribunal, how much do they usually charge for the reviewing of the applications?
Oh, do you mean because he's unemployed, he can get a reduction in the fee of the AAT application?
Yeah, that's the one.
Oh, right. I was looking back through the question going, a fee for the security license. I don't remember writing that. It's not as much as you might think. And there's a bit of discretion involved. It's not the same rate for everyone. It's probably changed since I went through it, but they can do, it depends on, it's not just you're unemployed, so you get 50% off or something like that. They do look at the circumstances, and what they're really looking for is sort of issues of financial hardship, of which being unemployed is obviously part of that. But, it's not just as simple as you get unemployed, so you'll get, X amount of discount. So yeah, I'm afraid I can't give an exact answer on that one, but yeah, good thinking outside the box. I wouldn't have necessarily expected that in an answer, if that was an assessment question, but yeah, creative thinking like that, as long as you don't go too far down too far off topic, is never a bad thing. Would the decision be of a law enforcement nature? I'm afraid I'm not quite clear what you're asking with that one.
Because the decision was put towards the police commissioner as well as, and the Security Personnel Act is sort of law enforcement in nature, as they have the same sort of powers. With that, it seems like a bit of grey area to me, but if the decision is of law enforcement nature, it's exempt from merits review. And I was just wondering if this certain situation would be exempt, but it's grey area, so I'm not sure. It's one of them, it depends.
Yeah, so you're talking about because the Commissioner of Police is involved?
Yes.
Yeah.
And the fact that security requires a license, and it is bouncers and stuff, when they're threatened and attacked, sometimes a person can be fined for the same amount as a law enforcement officer, because law enforcement can't be everywhere.
Yeah. The things that would guide you in this instance are, for one, although the Commissioner of Police provides the report on the criminal history, the Commissioner of Police isn't actually making the decision about whether someone's appropriate or not. They're just providing the background themselves, and then it's up to the chief executive to make the decision about whether someone is appropriate or not, based on what that report uncovers. The second thing that we can be guided by is that Section 26 of the Act specifically says that you've got a right to appeal to the AAT, so that they're being specifically empowered to, the AAT is specifically empowered to hear a review of that decision by the Primary Act, and so that governs the AAT's power, and so they would be able to. It's not, I can see where you're coming from in talking about it being a law enforcement issue, but it's that I can see the sort of grey area about, do security guards enforce the law and things like that, but it's still a clear separation between the police and security guards, and security guards would still fall very much on the sort of civilian side of things there. And so because the AAT is empowered, we wouldn't say that it was a law enforcement issue that would be excluded.
So that would mean that none of the security personnel would fall under that law enforcement sort of exempt from merits review?
No, not for
like
this
bouncers.
question. No.
I was talking about generally. I was curious on that, if it expanded, if in other circumstances involving security personnel, bouncers, airport security, courthouse security, would they be exempt from merits review for other circumstances? Sorry, it's a bit broad. I probably shouldn't have brought it up. It's just something niggling.
Yeah, no, that's fine. And I mean, the sort of the answer, even though it's not very helpful, is that it depends. And as always with these things, we're guided by the Primary Act, empowering or disempowering the AAT to make a review. We're further complicated here because that the legislation here is not real legislation. It's just a hypothetical one to you know, because in this unit we're focusing on Commonwealth law to be consistent right across, you know, we're studying from all over, and so we're focusing on the Commonwealth level to be consistent. I've taken, I think it was from Queensland, might have been New South Wales, a Queensland Act, and, you know, pulled bits out of it and made it a Commonwealth Act. So it's not necessarily completely grounded in reality either, which probably complicates the answer a bit as well. But you, as a general rule, in deciding whether merits review would apply and whether the law enforcement exemption would apply or not, you'd be guided by whatever the primary act says. If the primary act says merits review applies, then merits review applies. As a very broad generalization, I wouldn't have said security guards and bouncers would necessarily fall into that law enforcement category most of the time, but it does depend on the primary act. Glenn's asked if it's worth noting that the AAT has the discretion to extend time for applications. It would be worth noting if there was something in the facts to indicate that we were outside the time, which there isn't in this instance. It's probably worth saying, just for completeness, that even though the AAT has discretion to extend time, there has to be a good reason to extend time. So generally, you could note it if we were outside the time, but the AAT, you know, they're busy. They've got enough applications coming in as it is. They will only do it if there's a really good reason to extend the time. For example, the decision was made, the notice was given in the sense that the letter was all typed up, but then, you know, it got sent out, but then the post office burned down and the letter was destroyed, and you didn't actually get notice of the decision till 3 months later or something like that. That might be a good enough reason to exercise discretion to extend it, but as a general rule, I wouldn't be saying, oh, you know, the time limit's 28 days. We're 40 days in because you never opened the letter and now you're only just seeing a lawyer. They're not going to give you an extension for that. So I wouldn't, in terms of a hypothetical, I wouldn't make a big deal about it unless there was something in the facts that you were given to indicate that there would be some reason for the AAT to give an extension or something like that. But for the most part, I wouldn't be too worried about that. Let's jump in and talk then about an answer. And Timo, if you wanted to share yours, that would be great. It's completely up to you. Otherwise, we can talk through, you know, the suggested answer structure from the slides and things like that as well. And if anyone else has sort of prepared their answers as well, then that's, you know, feel free to share yours as well, or pop something into the chat too.
Yeah, so this is this really scaled down version. Please comment, everyone. So I'm always happy for feedback. So
while you find that, Tim, I'll just answer Gory's question in the chat. Will it be helpful to look at previous decisions as to what is lack of integrity association with a criminal? In real life, yes, it would be. For the purposes of assessment, I wouldn't be expecting you to go into the specific, like, you know, case authorities on the particular issue. You know, I expect you to know cases that I've talked about in the study notes and in the lecture materials and in the textbook. I don't expect you to go out and find new cases on, you know, what would be an appropriate person for a license and things like that, unless I've talked about it in some of the study materials. So I guess the broad answer is that you don't have to do too much extra research for this course. And the way that applies to this one was that you could go out and look at previous decisions about what is a lack of integrity in association with criminals and things like that, but you wouldn't be expected to make an answer. To answer, so Timo's answer here, there's a mistake on John's application that would need to be reviewed. Under section 25, an act must deliver a review by the AAT from the decision made under the enactment. John can challenge the decision under a merits review in pursuant of section 26 of the Security Act. As the error was made by the chief executive in terms of John's identity, there is an issue of fact. And new information would need to be presented to the tribunal. Reference to Drake, which is good to see. The tribunal's function is to reach a correct and preferable decision. I love it. AAT would stand in the footing of the decision maker to review the matter. Yep, the AAT refers to the tribunal that the tribunal can initiate its power over a decision only when it's precisely limited but permitted by legislation. There was an incorrect decision made. John, the applicant, must have standing. Section 27, good to see. The application must be made within 28 days. Yes, within the application lodgement, there is a fee. I wouldn't worry about the fee so much as John is unemployed. He could get a discretion. Yeah. So, yep, we're touching on some good things here, which is really good to see. We might run with that a bit. And really, and, as you've said, this is just sort of a skeleton answer. So, I'm in saying things to add, I'm not sort of criticizing what's there or not there. But thank you very much for sharing that, Timo. The starting point, the logical starting point here is to say, is merits review available or not? And so to note section 26 of the Security Personnel Act conferring power to review on the AAT, and to note section 25 of the AAT Act, which says that primary legislation can confer power on the Act. So noting the legislation in the Primary Act and section 25 of the AAT Act together to say this is something that we can go to the AAT to for a review is a great place to start a merits review answer. Then you could move on to look at time limits. You can do time limits sort of towards the start or towards the end, but looking at time limits and mentioning the 28 days limit that's in section 29 of the AAT Act, unless it's varied by the primary legislation, which it's not. Sorry, in talking about whether merits review is available or not, I'd mentioned standing there as well, which you've got there, Timo, which is good to see, just to note. And to note, one, you need standing, and then to say, John is affected by this decision because, it not getting the license is a disadvantage to him, therefore he would have standing. That's enough. Just a quick sentence to check off that he's got standing. That's good. So then moving on to timing, 28 days unless stated otherwise. The procedure for lodging the review, so in writing to the AAT under section 29 of the AAT Act. And then we'd move into the powers of the review body, so the AAT, where we note that section 26 of the Security Personnel Act says that the AAT's decision is unaffected by the chief executive decision, and that they exercise the same powers as the chief executive in making the decision. What that means is that invokes the correct and preferable decision under Drake, which your answer is identified, Timo, which is good to see. And then having sort of gone through all those preliminary issues, then we're getting at correct and preferable from Drake. And then you expand out into the answer to talk through, okay, well, what is the correct and preferable decision here? Correct being, free from errors of law, preferable being free from errors of fact, basically. So the correct decision in this instance would be to make a decision about John based on John's criminal record, not someone else's criminal record. So you'd make an argument there that the correct decision or the decision made has been incorrect because it's based on someone else's criminal history, not John's criminal history. When we look at John, he doesn't have a criminal record. So the correct decision would be to say that he is an appropriate person because he doesn't have a criminal record. In terms of the preferable decision, you'd look at the comments that the employer made about, well, this is an appropriate person, but he's late all the time. And make an argument there about, okay, well, if someone's late, does that mean that they're not appropriate to be a security guard or not? And because John's our client, we're going to make the argument that that shouldn't be a disqualifying factor, which I think someone mentioned in the chat earlier on as well. So looking at, let me get the sections, the things that you can pay attention to, whether someone showed dishonesty or a lack of integrity or used harassing tactics or indicates that someone associates with criminals. Being late doesn't touch on any of those things. And so they don't speak to John's appropriateness as a security guard, and therefore the preferable decision would be to say that he is an appropriate person. So that's that. You sort of, and thinking about the structure of the answer as a whole, you go through some preliminary steps to say merits review applies and this is how we get it kind of thing. Then you talk through this sort of the legal points of what is the tribunal, in this case the AAT, empowered to do, and that gets you to the point of Drake. They're empowered to look at getting the correct and preferable decision. And then that allows you to go into, so those are all fairly straightforward, one sentence, two sentences for each point. And in terms of from a marking perspective, it's just sort of tick or cross, have you got it or not? Then once we get to correct and preferable, that's where you bring in your nuance, your argument, your critical attention to what's going on. And that's where you can really show off your understanding of the material by making a nuanced and complex argument about what the correct decision would be, what the preferable decision would be, and really engage with the facts that you're given. Then you sort of go back into a bit more of a sort of nuts and bolts stuff and talk about, okay, well, so what are the powers of the tribunal in terms of, do they just have to set the decision aside? Can they remake the decision? If so, what's the effect of that decision? Things like that. And so it's sort of, expand out and then a few more boom, boom, boom sort of thing. If that makes sense, it's sort of hard to explain audibly rather than having it in front of you. But really just crossing off each step, and then within talking about correct and preferable, that's your opportunity to really engage with the facts that you're given in the hypothetical, and to really go through, okay, well, what are the arguments that I'm going to make? What would the chief executive say in response to those arguments? A bit of back and forward, and then reach a tentative but critical conclusion about, okay, but under these circumstances, this argument is likely to succeed because something like that. The other thing that we should talk about is reasons for decision. We'll very briefly do it because we did talk before about, the reasons currently are inadequate because they haven't provided evidence and they haven't really clearly stated the facts on which the decision was made. If we were answering this question like you will with your written assessment, where you'll need to showcase your knowledge of both the Access to Information Week and the Merits Review Week, what I would say that you probably should do is do the reasons for decision and access to information stuff first. So start off with, we've been given this decision, but we don't have the full reasons. Talk through, what are the reasons? How do you access them? What are the decision makers' reasons likely to be? So, for example, they haven't stated the evidence on which they've relied, but what is that evidence likely to be? And things like that. And then that's where, if you feel like there's gaps in the sort of factual matrix, that's where you can make a few assumptions. Is probably too big a stretch of a word, but so for example, here you could say, we can reasonably assume that the evidence that the chief executive has relied on is this statement by Mary that he's late and that the criminal record was for someone else. It's not a giant leap. I don't want you saying, oh, well, they haven't told us what his birthday is, so it's probably the 25th of November or something. Like, don't go wildly off on a tangent. But if there's something that it's not too far of a stretch to assume that something would or wouldn't be in, that's where you can make a note of that. And then to the extent that that influences the rest of your answer, that can be included in it. So I'd start, as I said, with access to information, talking through issues with the reasons, whether you apply for any documents via freedom of information or not. And then based on sort of the factual package in terms of what you've been given and what you could reasonably expect to uncover via the access to information process, then you go into your merits review and you sort of step through the things that we've talked about just for now. Does that all make sense? We'll be having a session in week 5 talking much more about the assignment itself and really talking through how to go about the answer. But what I can say now in these last few minutes of today is that you now have everything content-wise, you now have everything you need to answer the written assessment task. You obviously don't have the question yet. That comes out at the end of week 4 and is due at the start of week 6. We've got week 5 almost completely off to give you time to work on that. And we've got the midterm break. So there's plenty of time. You don't have the question yet, but you've got all the content you need to answer that written assessment because it's going to be on access to information and merits review. What that means is that, if you want to get a bit of a head start, if you want to be a bit proactive, start going through your notes, making sure you're completely comfortable with the content from the past couple of weeks. If you've got questions, now is definitely the time to get in touch rather than in a couple of weeks' time when everyone's madly scrambling to do the assignment and asking me questions then. Get in early, ask me now. I've got much more time now than I will in a couple of weeks. And start, making sort of a skeleton of an answer. You know that you're going to have to talk about whether reasons are adequate, what the process is for asking for better reasons or reasons if none have been supplied. If you think freedom of information might apply, what are the requirements, things like that. Then all the dot points that we've talked about in merits review. So you can tonight, tomorrow, whenever, you can actually start to construct a little bit of your answer. And then once the question is released, you can fill in some of the blanks and, obviously you'll edit it and you'll make the progression much smoother. But what I'm saying is that there are things that you can be doing right now to prepare for the assessment when it does come out in a couple of weeks. So making sure that you're happy with the past couple of weeks content and starting to think about, structuring problems based on access to information and merits review. And I've now given you the tools for those as well. If you can be proactive with that, you'll be off to a really good start with this written assessment. Are there any final questions? Otherwise, we've now hit 6:01, so I do have to let you all go and go about your evenings. But are there any final burning questions?
Can I just ask one super quick one, Jacob? Just, I know you've said we've got all the content and everything. I'm just, the structure is, I guess I'm a little bit OCD. So I like to know exactly what the lecturer wants. Like, do you want a heading of jurisdiction like that, like the thing that you put at the end of our PowerPoint? You said an answer guide that had jurisdiction procedure. Do you want headings? Do you want it in an essay format? Or are we going to go through, is that what we're going to go through closer to the date? Like, I know IRAC isn't what we're doing in this unit. So is there something similar, or is it just, like you said, just follow the flow of what needs to be said and use whatever headings you think are necessary?
Yeah, we will talk about that in a bit more detail in week 5. You will also, in terms of access to information and merits review, that will actually be sort of broken up into 2 questions in terms of, question 1 will be something about what are the issues of to access for information, but that's essentially what it will ask. And then question 2 will be, what is merits review available? And if so, what would you do about it, kind of thing. So that already kind of separates out a bit of the structure. But it's also useful for you to think about the problem as a whole, thinking about reasons first and then merits review. In terms of sort of smaller than that, sort of step-by-step headings, headings are good, but don't go overboard with them. And the reason I say that is because I sometimes find that people, when you have too many headings, you don't end up, I guess, giving yourself enough space to talk through the nuances of the ones that you need to. So I would do, we'll talk more about it in week 5, but I do, for example, with the merits review stuff, I'd have a merits review heading, and then I'd have, is merits review available? And then you could talk through, the issues of Section 25 of the AAT Act and the Primary Act and standing all together. I wouldn't separate those 2 out into further subheadings. What are the AAT's review powers? And then you could talk through everything, what does the Primary Act empower them to do? Correct and preferable decision, the nuances of all that, all within one heading. I wouldn't break that down into further subheadings. If people are interested, what I can do for week 5 is come up with, I don't want to say it's an answer template because it's not something that you're locked into, but some suggested headings for an answer, if that's something that's of interest. But it wouldn't be like a required, if you don't have these headings, you lose marks. It would be this is a suggested way to get a really clear, and it's for you, it's mostly for you to help you structure your thoughts in relation to the answer and making sure that you're picking up all the issues, rather than necessarily for me in terms of, what am I looking for in terms of marking it. But it sounds like there's a consensus that would be a useful thing. So I'll come up with that over the next week or so and put that up on Moodle. And then, you'll see as well, sort of, I guess, a bit more clearly, more visually, what I've been talking about in terms of thinking through the different issues and structuring it in that way.
Thank you.
That's all right. Any other questions or concerns? Brilliant. Well, we'll call it there. Thank you all very much for coming along. Next week, we'll be back to talk about the sort of the first stages and the first concerns that we've got in relation to judicial review. So I look forward to seeing you all then. If you've got issues in the meantime, of course, please do get in touch. But otherwise, we'll see you next week. Bye.